EHCP in the name of London Borough of Hillingdon and
Mr. Thomas.
My Lords, it's easy to put. My name is Mr. Joseph Thomas and I represent the appellant to the appeal. For Miss Anderson and Mr. Hirschman are called the respondents. Please may I begin by putting on record my appreciation for the professionalism and courtesy with which I learned friends have prepared for this case. In terms of housekeeping, in terms of progress, my Lord, I was proposing to deal with this in seven steps. First, matters of housekeeping. Second, an introduction and update. Third, to take my Lords through the legislative scheme. 4, to go through the decision letter. And then 5, to deal with submissions. And then 6 and 7, to address the court on questions of remedy and whether or not this claim is academic. With your consent, I will now turn to the housekeeping matters. May I confirm that your Lordships have an anonymised core bundle of 145 pages, a supplementary bundle of 98 pages, which I only anticipate taking you to once, and an authority bundle running for 434 pages.
Michael, I can't confirm the page numbers without going and looking, but I can see where I am.
Thank you.
I'm ahead of you. I can confirm the page.
The skeleton arguments for myself and Miss Anderson are at the front of the core bundle, but I have separate copies if that would assist the court.
If we need them, we'll ask.
Thank you. And since this appeal is under the Tribunal's Courts and Enforcement Act 2007, I also have copies of the relevant section of that case, that legislation as well. And I also have rules of the First-tier Tribunal, should that be required as well. At paragraph 3 of my skeleton argument, you'll see a list of shorthands that I have adopted and that I believe Anderson has also adopted in today's hearing. If I could beg your indulgence for one small matter, at paragraph 24 of my skeleton argument, there is a small typographical error that I would just wish to clarify, which I've already brought to Ms. Anderson's attention. You'll see in the second line, a section in parenthesis begins. It reads, in this case, what provision is reasonably required and which provision is appropriate to deliver it. That should say, and which placement is appropriate to deliver it. I apologise to the court. Unless there are any further housekeeping matters I can assist with, I was going to begin my introduction and updates. My Lords, this is an appeal brought under sections 13 and 14 of the Tribunal's Courts and Enforcement Act 2007 against the decision of the Upper Tribunal to uphold a decision by the First-tier Tribunal concerning the educational provision reasonably required and the placement of pupil AA, who has been anonymised for obvious reasons. At the core of this case are, in my submission, 3 straightforward questions. Did the First-tier Tribunal conflate the need for an extended day with residential placement and therefore fall into error? The First-tier Tribunal conflate questions of provision and placement and therefore fall into error? And did the First-tier Tribunal fail to grapple with its duty to avoid unreasonable public expenditure and therefore fall into error? By way of context, up and down the country, local educational authorities with overstrained SEN budgets are having to implement First-tier Tribunal decisions to educate pupils at exceptionally costly independent placement. And given local authorities, educational authorities' overarching duties to others and to ratepayers, it is a point of agreement. One would assume that the First-tier Tribunal, being the decision maker but not the budget holder, must apply the law rigorously and the evidence rigorously. In terms of updates, I'm informed that pupil AA is settling well into her school and that she is a lively pupil with a cheeky sense of humour.
Would you say settling into the school? She's been there since January 25?
Yes, it is a happy placement.
That's school E.
Sorry?
That's school E.
Yes, that's correct. With my Lord's consent, I was therefore then going to take you through the legal framework. I mean no discourtesy if I go into detail, and please let me know if there are any matters where you feel I can be overly cautious in taking you to. But if I may, I'll begin with section 9.
You can certainly take it that we've read in quite thoroughly, but I'm not suggesting that you really take it.
Thank you, my Lord. Lord, there are certain matters I would like to draw your attention to as we
Yes,
go
of
through
course.
this. My Lords, if I could begin with Section 9 of the Education Act, which I'm sure you're very familiar with, and if my learned friends and I took the view that it was disproportionate to the contents page, given that we were only quoting one section and no discuss what was meant by that. You may know the Education Act itself runs through approximately 496 sections, and that was honestly very unnecessary. But you'll be very familiar with Section 9, which, in exercising and performing all their respective powers and duties under the Education Act, Secretary of State and local authorities shall have regard to the general principle that pupils are to be educated in accordance with the wishes of their parents, so far as that is compatible with the provision of efficient instruction and training and the avoidance of unreasonable public expenditure. As discussed below in terms of submissions, it will be my overarching submission that it's a relatively weak provision. I now turn to Part 3 of the Children's and Families Act, and I begin with Section 19, which begins at page 22 behind tab 2. In exercising a function under this part, in the case of a child or young person, the local education authority in England must again have regard, so we see the same language as Section 9, to the following matters. And the most important of those is the views, the wishes, the feelings of the child and his or her parents or young person. I draw that to your attention at this stage because that may be appropriate to the question of how you in turn approach the question of appropriate itself in context of Section 40 and 39. I then turn to Section 20, which is the definition of special educational needs. And it has some, and this is the same language that was used in the previous legislation. A child or young person has special educational needs if he or she has a learning difficulty or disability which calls for special educational provision to be made for him or her. And so there is a causal link, as I will develop further, between the nature of difficulty and disability and what it calls for. And then you'll see that at subsection 2, child in compulsory school age young person has learning difficulty or disability, significantly greater difficulty in learning than the majority of others the same age, or has a disability which prevents him or her from making use of facilities of the kind generally available. And then if we turn the page, my Lord, to section 21, you'll see the definition of special educational provision, which is for a child aged 2 or more, young person needs education or training provision. So it must be educational or training that is additional to or different from that generally available for children the same age. And if I could just make an observation, you'll note that the definition of special educational needs and special educational provision is somewhat circular, and that is what it is. Special educational needs exist when provision is called for, and provision is only necessary when there are needs. Sections 22 to 32 lay out various duties for local authorities and others to work together, consult and provide what's known as the local offer, and I don't intend to take you through that in detail. So I then turn to section 33, my lords, which you'll find at page 51 of the authorities bundle. My lords, you'll note that this is the provision applies where this section applies where a local authority is securing preparation of the EHCP plan for a child or young person who is to be educated at school. In a case within section 39.5 and section 42, and section 42 was the section that was engaged in this case, the local authority must secure that the plan provides for the child or young person to be educated in a mainstream nursery school. And then there are two very strict exceptions, very tightly defined exceptions. I draw that to your attention at this stage, because that may be relevant to the way that the court approaches the question of appropriate under section 42. Section 34 makes provision for children without EHCPs, Section 35 concerns nursery schools, and Section 33 describes the purpose of assessing whether a child needs an EHCP. So I then, with your leave, take you to Section 37, which begins at page 59. And you'll see at subsection 37.2, the provision lays out the detail that is expected to be included in an EHCP plan. And that you can see that it's subject to regulations. I then turn to section 38, my lord. You'll note that where a local authority is required to secure a plan, for young persons, must consult parents and young persons, etc., etc. But if I could draw your attention to subsection 2b, you'll see that the local authority must then give the parent or young person notice of his or her right, I just pause at that word, to make representations about the contents of the draft plan and request the authority to secure that a particular school or other institution within subsection 3 is named in the plan. The school in question here, School E, did not fall within subsection 3. You'll then note that the draft EHCP plan sent to the child's parents or young person must not name a school or other institution or specify a type of school or other institution. And I pause there to note that in terms of drafting an EHCP plan, it's section B and section F that are done first in draft, and then section I is left blank for parents to essentially fill in and then be considered. I then would like to draw your attention to section 39. Now, although this case fell outside section 39, I would like to draw some differences between section 39 and section 40 to your attention, my lords. So this section applies where section 38(2)(b) is complied with the school at the parent's request, a school that was shortlisted under section 38(3). And you'll note under subsection 4, the local authority must accede to that request unless these narrowly drawn exceptions apply. The school or other institution requested is unsuitable. They didn't use the word inappropriate, they used the word unsuitable. To the age, ability, aptitude, special educational needs of the child or young person concerned. And so it's not just unsuitable generally, it's unsuitable against that criteria. And then there are two further exceptions. The attendance of the young child person requested at the school or other institution would be incompatible with the provision of efficient education for others, i.e. it will have an unacceptable impact on their classmates, or incompatible with the efficient use of resources, which is a different test from section 9. Where subsection 4 applies, subsection 5 is engaged, and that requires the local authority to then name a school that they think would be appropriate. Again, not suitable, not inappropriate, etc. So I'm just noting the language at this stage. At section 40, we have the situation where a parent doesn't specify a school under a notice under section 38(2)(b), i.e. chooses a school outside that shortlist. The local authority must secure that the plan names the school or other institution which the local authority thinks would be appropriate for the child or young person concerned, or specifies the type of school or other institution which the local authority thinks would be appropriate for the child or young person. Section 41 concerns the process for registering a school, an independent school, so it falls within section 38(3). And you'll note that a school can only be section 41 registered with the school's consent. So it's a system that they opt into. But the consequence of that is that if the school is then named, they have to admit the child.
What are you looking at?
I beg
Where
pardon?
are you? What are you looking at? Your last submission was on what section?
So I'm still on section 41, my lord.
Thank you.
Section 42 and 43 deal with the duty to secure provision. Section 43 includes the duty for a school to admit a pupil named in such an institution, including under section 43 1F, an institution approved by the Secretary of State under section 41.
Section 41 isn't relevant in this case, is it?
It's relevant in a contra example in that the school in question, School E, was not section 41 registered. And then we have section 44, which reminds us that we may review the plan. Section 45 is the process for ceasing the plan. I should have mentioned that section 44 reminds us that the plan should be reviewed on an annual basis. Section 46 confirms that a local authority may continue to maintain an EHCP plan for a young person until the end of the academic year during which the young person attains the age of 25. Although it's framed as a discretion as in may, as we'll come on to, you'll see that Regulation 30 heavily limits that discretion. I don't believe there's a point in principle between us that sections 47 to 50 are not engaged in this case. So I then turn to section 51 on the scope of appeals. A child's parents or young person may appeal to the First-tier Tribunal against the matter set out in subsection 2, subject to section 53. And you'll see under subsection C is the extent to which parents may appeal the contents of an EHCP plan. The child or young person's special educational needs is specified, special education provision specified, the school or other institution named in the plan, or the type of school or other institution specified in the plan. So the scope of the appeal is not entirely, it doesn't map on perfectly with the contents of an EHCP, as is other sections, section A, section E, which do not, which are not subject to appeal. Subsections 52 to 60 address mediation and other technical changes required for appeal rights, so I was going to take my lords to page 105 in section 61. And I pause at section 61 to note that a local authority in England may arrange for any special educational provision that is decided as necessary for a child or young person for whom it is responsible to be made otherwise than in school or post-16 institution or at a place at which relevant early years education is provided. An authority may only do so if satisfied that it would be inappropriate for the provision to be made in a school or post-16 institution or in such a place. I just note at this stage that this section has potential relevance to this case, as it follows that just because a pupil requires special educational provision and that it extends beyond the typical school day, it does not necessarily follow that it must be made at a school. There is provision within the legislative scheme for that to happen. Section 63, if I may, my lord, addresses the question of fees. And under 63(2), the local authority must pay any fees payable in respect of education or training provided for the child or young person at that school, institution or place in accordance with the EHCP. Subsection 63(5) provides that where board and lodging are provided for the child or young person at the school, post-16 institution or place mentioned above, the authority must also pay any fees in respect of board and lodging. If satisfied that special educational provision cannot be provided at the school, post-16 institutional place unless the board and lodging are also provided. I just pause there to note that there is a distinction in the fees section regarding board and lodging and school fees. The following sections predominantly deal with pupils who are detained, which is not obviously relevant in this case, and so I then turn to section 77, which is at page 137. Which provides that the code of practice is a mandatory consideration, and the authority for that is section 77(6). First-tier tribunal must have regard to any provision of the code that appears to be relevant to the question arising on appeal. So that's this part. And then finally, from the Children's and Families Act, if I could just take you to page 149. And this is the interpretation of part 3. And then you'll see the final subsection 7 says the Education Act 1996 and the preceding provisions of this part, except as they so far as they amend other acts, are to be read if those provisions were contained within the Education Act 1996. Just to confirm that this is all part of one scheme. You'll be relieved to note that I don't intend to go through the regulations in the same amount of detail, but if I could draw 3 provisions to your attention, my lords. At page 164, you'll see paragraph regulation 12, which is the form of the EHCP and the letters that I'm afraid you'll become all too familiar with of section B, section F and section I. If I may then take you to regulation 30. And this is circumstances in which a local authority may not cease to maintain an EHC plan where the person is aged 18 or over. And you'll see that the discretion that I mentioned earlier is heavily described. And then
Do we need to be concerned about this?
the issue arising from the EHCP being effectively obligatory until the age of 25 is the cost implications that arise from a particular placement, because that is system. And then in terms of regulation 43(2), which concerns the powers of the EHCP, sorry, the powers of the First-tier Tribunal, apologies my lords, that's at page 181. Again, you'll see that they have, when it comes to updating the panel, they have broad range of powers to essentially supplant the role of the local authority. Unless I could give any further assistance to the regulations, those were the ones I thought it was necessary to take.
Thank you.
I then turn to the code of practice that we have only obviously provided an extract from. Were you assisted by the entire code of practice, that would obviously be provided. If I could just draw your attention to 2 points, and you'll see that there's a table at page internal page 166, but bundle page 205. And the code of practice specifies that what should go into a plan. And if I could take your lordships to the first bullet point under section F, again on page 205. Provision must be detailed and specific and should normally be quantified, for example, in terms of types and hours, frequency of support. And that's qualified though by bullet point 5, which says in some cases flexibility will be required to meet the changing needs of the child or young person, including flexibility in the use of the personal budget. And then at the bottom of page 205, internal page 166, where residential accommodation is appropriate, that fact, which I will address in my submissions. I'm sure I haven't obviously provided the first-tier tribunal rules, but you won't be surprised to learn that they enjoy wide ranging rules of case management, including the power to adjourn. I have, as I mentioned there, I have got a copy of those should that be used. Unless I could give any further assistance with the legislative scheme and the policy scheme, those were the only matters I wish to draw to your attention in terms of an introductory framework. With that in mind, then, I would like to then turn to the decision letter itself, which is behind tab 11 and at page 97. If I may, however, begin with what is known as the working document, and you'll see that that is at page 110 of the bundle, and there's a key explaining what all the different typefaces mean and how that feeds into the deliberations of the first-tier tribunal. And you will note anything bold is the parents' proposed suggestions or deletions. And if I could just draw your attention to just two aspects of this. At page 132, they're both on the same page. You'll see on the right-hand side, my lords, that it was broken down into columns about who will provide it. When parents were making their applications for variations, you will note that they weren't making an application for residential staff to be included within the individual solution delivery provision. However, I should also draw your attention to the fourth point down, where at the end of an underlined section, parents were asking for the inclusion of which only a residential education can provide. So it would be remiss of me to suggest that the parents were not putting forward an argument that residential placement was required, but I do note that they, under the staff who were to deliver it, there was no suggestion that it was going to be delivered by residential staff.
Sorry, I didn't hear that. No suggestion it was going to be
Delivered by residential staff.
Is that reference, I haven't checked now that you've drawn our attention to it, but in the EHCP that we're considering,
Yes.
is that the only reference, other than in section I, to residential?
As far as I'm aware, I'm sure Miss Anderson will correct me if I'm mistaken, but I did do a search and that was the only RESI that I found. But I will repeat that search over lunch break. So with that in mind, I then turn to the decision letter itself. I'm sure Miss Anderson will correct me if I omit anything, but in this stage, I just wish to draw your attention to everything that both Miss Anderson and I would like to draw to your attention. But if I do miss anything, I'm sure Miss Anderson will remind me. So in terms of what I would like to bring to your attention is paragraph 2. The tribunal does obviously mention part 3 of that Act, Children's and Families Act, and it obviously mentions together with section 9 of the Education Act, 1996. So again, it would be remiss of me to suggest that they were completely oblivious to section 9. The next paragraph I would like to take you to is paragraph 8, which provides an update on pupil AA, and that says that she's been out of formal education provision since July of 2023. Parents have chosen not to take up the offer of the place, and that there were serious concerns regarding the work of the social worker, and that the living conditions were not appropriate, and the parents were candid in their struggles for caring for AA. Paragraph 9, the First-tier Tribunal identifies what it considers its fundamental question. And I will go on to initially formulated correctly in that as to whether she requires an extended curriculum with provision being available to her outside of the school setting and outside normal school hours.
Sorry, where are you?
Apologies. I'm at paragraph 9 on page 99 of the core bundle of my work. The continuing dispute in this case resolves around the provision that pupil AA requires, section F, and the fundamental question as to whether she requires an extended curriculum with provision being available to her outside of the school setting and outside of normal school hours. And then they clarify that we will avoid using the term waking day curriculum and we will refer to an extended day residential provision in our consideration of these matters. So at the start, they're conflating, in my submission, extended day and residential provision. At paragraph 11, local authority.
So you dropped in your submission there what? Something extended day and what?
Residential provision are being conflated. Treated as
For the
one.
purposes of the shorthand.
Not necessarily as purposes of the shorthand, but in the sense of that they are merging two questions together as one, and they're automatically inferring that if pupil AA requires an extended day, therefore she requires residential provision, rather than treating it as two separate matters. At paragraph 11, the local authority case is laid out, where they argued unsuccessfully that all the provision can be met within a not typical school day. But they did also note the very significant cost differential and did raise the issue of seeing whether or not a placement there would be perhaps the avoidance of unreasonable public expenditure.
Was it being submitted that there was the possibility of an extended school day that wasn't residential?
Beg your pardon, my lord?
Was it being argued that you could have an extended school day that wasn't residential?
It wasn't explicitly argued before the tribunal, and it would be remiss of me to say that it was. And that will come on to the powers of the tribunal to adjourn, having ruled that an extended school day was required, about whether or not they should have used their case management powers to direct the local authority to present an additional case, or they should have considered using their case management powers to see if they could square the circle or untie the gordian knot being pulled in different directions.
Are these the case management powers to which the Upper Tribunal referred?
Yes.
Yes.
If I could then take you to paragraph 12, and this is at page 100, and if I could just draw your attention to the headings, which don't have a paragraph number but are important nevertheless. You'll see that it starts Special Educational Provision section F, and then the following immediate heading is Extended Day Residential Placement in Principle. And then as I'm going to I just draw that to your attention, and I will develop that further. And then paragraph 12 itself, you will see the self-described narration of the thought process. You'll see that they're sequencing their thoughts in my submission, and that they say they will deal with one issue initially, they'll approach that issue thematically, and in particular consider the evidence in relation to whether pupil AA reasonably requires an extended day curriculum and residential provision, and then subsequently we will then go through the amendments. Just note that paragraph in that it is the self-professed sequencing of the First-tier Tribunal.
Do you take issue with the use of the word reasonably requires?
When no issue with the issue reasonably requires, that is the common test within the First-tier Tribunal. No one's entitled to a Rolls-Royce education, but it must meet a reasonable standard. Paragraph 17, I just pause to note that there is consideration of the evidence of Dr. Hyman's of placement whilst we are under a heading noted as section F. And we see that similarly at paragraph 21 in relation to Ms. Spinks. And then again at paragraph 23, we see reference to the use of the word extended day residential provision was not required. Again, they're being used synonymously in my submission. And then at paragraph 26, you'll see that the tribunal was aware of the possibility that pupil AA requires special educational provision to be made outside of an educational setting and outside of normal school hours. At that stage, we would say the previous sentence where they say extended school day and residential provision, they have not grappled with the question of whether or not the one requires the other. At paragraph 30, again coming to this.
Just before you get to
Oh.
30, may I just pick up a query I've got at paragraph 29?
Yes, ma'am.
This is just over halfway down that paragraph. The parents, as a result of previous and it seems to an extent accepted failings of AA's previous school overseen by the same trust. Do I read that it was common ground between the parties before the FTT that the school that AA had attended up to July 2023 had failed her?
I have no reason to read it any other way, as that was the accepted position of the local authority. May I just pause for one second? I have no further comment.
And the tribunal goes on, and there appears to have been, which I take as a consequence of just referred to, a complete breakdown in communication and trust. That's between the parents and the local authority.
No, between the parents and the trust.
The trust.
Yeah.
At the end of paragraph 29, it's quite plain that the tribunal's understanding is that the choice here is between day placement and a residential.
Yes, my lord, and that feeds into my submission that they are putting the cart before the horse, as it were, and that they are, instead of asking themselves what is the provision reasonably required to meet this young person's needs, and then specifying that with appropriate detail, only then should they then turn to the question of placement.
Well, but if at the end, I mean, these things aren't done in a vacuum. I mean, if the local authority wasn't suggesting that anything other than a residential placement would be capable of providing the extended day needs.
Yeah.
At this stage, this was a 14-year-old child.
Yeah.
Then why cannot the tribunal proceed on the basis that the ultimate dispute, plainly they need to go through the process to decide the issue that is dividing the parties. But if the ultimate dispute is does this child require residential placement or not, why can they not frame the question in that way? That is the ultimate dispute between the parties.
Yes, I would come back with two rebuttals, if I may. The first is you're anticipating what I'm going to say in regards to the case law, which appears to say part 4, as it was known, cannot influence part 3. In answer to your question about whether or not these decisions are made in a vacuum, and secondly, the question of placement. And I fear I'm at risk of repeating myself, so please advise me if I haven't answered your question. The question of placement can only be answered in my submission once the provision reasonably required for that young person has been specified. And equally, the question of placement has to be done with regard to that Section 9 duty. And in this scenario, in this case, the First-tier Tribunal had found that pupil AA needed provision beyond the normal school day.
Forgive me, why isn't residential an aspect of provision?
Again, you're anticipating a further argument that I was about to make, which is if we, in my submission, if we go to the legislative definition of provision,
Yes.
if we go back to section 21,
Yes.
There is a definitional challenge here, in that special educational provision for a child aged 2 or more of a young person means educational or training provision. So there's an essay question as to whether or not residential provision.
So are we on page 25 of the,
Yes, we are.
and which part of that?
Section 21(1). Yes. There's an essay question of whether or not residential provision is educational or training provision. In my submission, it isn't.
But does it matter if residential provision is what enables the appropriate educational or training provision to be given?
It facilitates it, my lord.
Yes, if I mean, there was one big question here, which was the way the judgments are structured.
Yeah.
Which was, could AA's needs be provided for other than in a residential circumstance? And that they're completely open about that being the big issue.
Yeah.
Does it matter whether you ask the RSA question that this is technically part of provision or facilitating provision?
There may be cases where education provision can only be delivered if the young person lives at the same location as provision. My response to that is that can only be assessed, as my lordship noted, not in a vacuum. And so that can only be assessed once you have the diagnosis, you have the treatment plan, i.e. the provision, and then you turn to, well, can this hospital, i.e. the special school, deliver it? And there may be cases where, for example, the transport may be impossible. There may be cases where the young person's need for generalisation is to such an extent that any break is unpalatable. But that can only be assessed against the proposed placement. And my submission is that the error that the First-tier Tribunal made here is that they jumped from the extended day, therefore residential provision, without the separate step of testing that against the potential placement.
Don't we get a clue to this from section 63(5) about fees? Where board and lodging are provided,
Yes.
must also pay satisfied. Special educational provision cannot be provided unless the board and lodging will also be provided.
Yes, we do.
So, I mean, as here, I don't think suggested other than that local authority would pay for the board and lodging.
Yeah.
What's being looked at, the assumption here is that the special educational provision
Yeah.
that is needed,
Yeah.
that provision comes with the board and lodging.
But
because it cannot be provided without it.
so my point is that they've jumped that conclusion in the sense that they have said, given the nature of people's AA's needs, she automatically requires residential provision without, in my submission,
Well,
systematically.
it wasn't being suggested to them otherwise.
No, I will.
So I don't see how they aren't entitled to jump to that. If two alternatives have been put to them, one is normal school hours,
Yeah.
and the other is extended school hours,
Yeah.
and the only suggestion is that that would have to be the residential school, then I don't see it would be. It's not the way we do things to say that they can't proceed on that basis.
But my submission is, and that anticipates what I'm about to say, what I'm going to say in terms of Hill Ground 3, is that when they came to the conclusion as a question of provision that it will go beyond the normal school day, they then should have tested it against the placements, and they would have, in my submission, I totally understand that they would have found school M wanting, and then they would turn to school E. But they were wrong to proceed as if that was a Hobson's choice, that they had to choose one or the other, given their case management powers.
This is the point addressed by Mr. Justice Altman.
Yes. In the Silicon case. May I return to the decision notice, and then I will of course return to my submission, but I'm of course very happy to answer any questions that my lords have.
Can I just put down a marker then, but when you get to the relevant part of your submission, that didn't the the First-tier Tribunal express its concern that, perhaps particularly because of the breakdown in trust, it would be very difficult to create an integrated programme of education for AA, partly delivered in a day provision at school and partly delivered out of school.
Yes, but I think also at paragraph 43, the FTC tribunal indicates that those concerns can be overcome with a professional approach.
I mean, in that sense, the FTT rejected the evidence of the expert that the local authority relied on.
Yes, yeah.
Which they were entitled to do.
Which they were perfectly entitled to do. But so I then turn again back to paragraph 30, which is having determined that we are satisfied in principle that pupil AA reasonably requires special education provision to be made so outside the school setting and outside the school hours, we must go on to consider the specific amendment sought of section F. And in my submission, that occurred in the wrong order, in that they should have thought about the specific provision, as we'll go on to see in terms of occupational therapy, in terms of physiotherapy, and in terms of speech and language therapy, that were required, before even answering the question of whether or not it was required out of hours. Paragraph 31 sees the first mention of residential staff, and then again we see mention of residential staff in paragraph 32 and 33. I remind myself that we are within section F here in their consideration. Section 34 states that residential provision is reasonably required. And then section paragraph 35 and 36 again mention the words residential. Paragraph 38 reiterates the LA's position going into hearing that the provision is not educational, but they obviously lost on that point. No notice was made about that. Paragraph 39 is, and it's perfectly proper that I draw this to your attention, that the main impetus of the appeal was in relation to placement and whether pupil AA requires extended day residential provision. On one hand, I note that again we're seeing the conflation of extended day with residential provision, but on the other hand, I should note that the suitability of the proposed educational placements is something we can only go on to consider having made determination to the relation to the provision that pupil AA requires, and I make no complaint about that, and it's perfectly proper that I draw that to your attention.
That's putting need before provision then, isn't it?
Which is,
Having made determinations in relation to the provision that AA requires.
yes,
So that's
that's fine.
a determination of need.
Determination of provision, my lord. The language used is, in terms of section B and section F and section I is B specifies need and F specifies provision. And then
placement.
And then placement, yes. And no discuss. And then paragraphs 40 and 41, you'll see that the assessment of school E is based on the assumption that residential provision is required. And then paragraph 43, the assessment of school M, that is dismissed on the basis that the school cannot provide an extended day / residential provision. Not just extended day, but extended day residential provision. School paragraph 44 confirms that a normal school day, paragraph 44 confirms that school M was confined to a normal school hours. And then paragraph 46 describes the heart of this appeal is whether or not The suitability of this school is that it cannot provide extended day, again, residential provision. And then at paragraph 48, and this is in relation to appeal ground 3, it concludes by stating, we do not need to go on to consider the reasons for parental placement or carry out placement cost comparison. And I will be addressing that in relation to appeal ground 3. My lords, I've had your attention for just short of an hour. I've gone through the legislation and the letter and the working document. Were there any other background documents you wanted me to address at this stage? So, my lord, I now turn to my submissions. Appeal grounds. I deal with appeal grounds 1 and 2. I appreciate there is a degree of overlap, but I will try and keep them as separate as possible. So in our submission, my submission, the Upper Tribunal judge erred in relation to original ground 1. And this in turn gives rise to 2 separate appeal grounds. The first is that the Upper Tribunal judge failed to grapple with the proposition that residential placement is not educational provision. And the second is that, contrary to the Upper Tribunal judge's conclusion, the reasoning taken as a whole does demonstrate back-front reasoning, putting the cart before the horse, and failure to apply the correct logical chain. If I may beg your indulgence, if I could take you to the supplementary bundle and pages 50 to 51. You'll see that I laid out for Upper Tribunal Judge Jacobs a number of propositions, and on page 51 you'll see proposition 2. Residential placement and extended day are not in themselves forms of special educational provision. And then there were 3 subsequent propositions. That Upper Tribunal Jacobs found against them. So I then turn to my appeal ground 1, my lord, and it is very simply this: that the Upper Tribunal in failing to apply the legally sound proposition that residential placement is not a form of provision, and that the extended day does not necessarily require or equate to residential placement. I propose to deal with this in 6 parts, if I may, my lords. I will address you on the case law, the statute, and the code of practice at the same time, the decision letter, such as to a further extent I need to, the Upper Tribunal judge's reasoning, and then the respondents' points in contention.
Before you do,
Yes, my lord.
just for my benefit, explain in 1 sentence why it matters that residential placement and extended days are not part of provision. What difference does it make in this case?
Because if residential provision is specified under section F, that would prevent a proper assessment under section I that's compatible with section 9 of the Education Act, would be my solution. In that you are narrowing the options to such an extent that you can't do a proper rigorous assessment of placement that is compatible with section 9.
Hence, this error prevents proper assessment in section 9.
Yes, my lord.
Thank you.
Would you like me to develop that point, my lord?
No, you've answered, you've given me your answer and develop it as you wish to as you go through.
Thank you. If I could begin by then taking you to my skeleton argument at paragraph 21. And you'll see a quotation that I don't believe in this disputing between us, and that I think the best to go into the bundle. and this is from Lord Carlisle of Berwick, sitting as Deputy Judge of the High Court of Reserve.
I'm really sorry. Whereabouts are you reading from now?
Paragraph 21 of my skeleton.
Paragraph 21. Sorry.
It's page 10 of my skeleton.
Thank you very much.
It's because it's not in the authority bundle.
Yeah.
I agree with the local authority that the fact that the tribunal identifies a consistency of approaches required going beyond the school day does not mean either that it's necessarily an educational need or that it can only be met by the way of residential provision. And then you'll note in my footnote, I also identify a further authority for that proposition, where the Upper Tribunal says it does not necessarily mean that it is an educational need which should be met with educational provision beyond the school day in a residential setting.
I think that plainly must be right as a matter of logic.
Yeah.
But then it's going to be fact specific, isn't it? I mean, there may be needs which require provision by residential staff.
Yeah.
Necessarily means residential placement.
Yes. But my submission is that the First-tier Tribunal fell into error by holding it automatically, as you'll note throughout, it said extended day / residential placement provision, and that it conflated the text and that it dealt with them. It concluded that from an extended day, the young person necessarily needs residential provision, because it dealt with it as one concept. If I could take you to a further authority in the appeals bundle, in the authority bundle, which is at behind tab 14. Page 381, paragraph 12. And my learned friend has provided this, but I think it's also important to look at the second half of the paragraph. As Mr. Ryland accepted, a residential placement is not necessarily required to deliver a waking day curriculum.
You know, so I may be looking at the wrong place. Can you
Apologies, my lord. It's at page 381 of this authority bundle.
Yes.
Paragraph 12, and this is Upper Tribunal Judge Jacobs in Southwark and WE. And Mr. Upper Tribunal Judge Jacobs states the residential placement is not necessarily required to deliver a waking day curriculum. That was before the phrase waking day curriculum was criticised again by Upper Tribunal Judge Jacobs, so it's now more commonly used as extended day curriculum in the First-tier Tribunal. So those were the two cases I wanted to draw your attention to, and then you'll recall that I've also drawn your attention to section 20 and 21 of the definition of special educational needs and provision, that circular definition as it were, and that the residential provision must be called for out of special educational need. And you'll also recall as your lordship took me to 63.5 separate board and lodging from special educational provision. So in my submission, the FTT erred because it did not grapple with whether the need to generalise or other special educational needs gives rise to provision and whether a particular school can then make that provision. Further, the question of whether a school can meet the provision can only, in my submission, be addressed once that provision is specified. And that comes down to my hill ground 2. So one school may only be able to provide that provision if it is complemented by a residential placement. I do appreciate that. However, another school may be able to do so without the residential placement. Accordingly, it is my submission that it's not possible to grapple with the question of whether or not residential provision is reasonably required until the education provision has been specified. And placements are then tested against that provision.
Was the local authority identifying or purporting to identify the alternative way? What was the alternative way of dealing with it? You had the two schools,
Yeah.
one of which was knocked out for the reasons given.
Yes.
Leaving school E.
Yes.
What was either of the tribunals meant to find? Should have been, because I'm not. It's probably my fault. I'm not conscious of what the alternatives were.
So the alternative was the local authority had presented its case on the basis that all provision met with the school day. It failed on that proposition. So it therefore found itself without a palatable school. In my submission, and this comes on to appeal ground 3, the first-tier tribunal should have paused and considered whether or not naming school E was compatible with section 9.
Shouldn't the local authority have gone to this hearing prepared to deal with the situation that it might lose its primary argument?
And I absolutely take the point that it should have been.
Why should this child's plan be further delayed while the local authority goes off to see if it's got some other options to consider?
I appreciate it is a deeply unpalatable and unattractive situation the first-tier tribunal finds itself in.
Well, why? Because presumably the first tribunal is entitled to sue.
Yeah.
If the local authority had a third option,
yeah,
which was extended day, not residential,
yes,
it would have presented it.
So we then come on to the inquisitorial nature of the tribunal, and that it is standing in the shoes of the local authority. It is subject to the same duties, the same responsibilities, the same the same responsibilities. And in my submission, it should have paused, and this comes on to appeal round 3.
The duty of the local authority is to put all the cards on the table.
Absolutely.
Which it either, unless you're going to tell us that it's got some terrific means of making proper provision for this child, which even now it should be admitted, which I don't think you are submitting. No. Well, isn't the first-tier tribunal entitled to rely to some extent on the fact that you haven't come up with an alternative?
I agree, and I would emphasise your words.
Well, if you do agree, what are you arguing?
To some extent, would be in that the first-tier tribunal, standing in the position of the local educational authority, has to grapple with the interests of this young person, but it also has to grapple with its legal duty to ensure that its placement is compatible with the efficient use of resources.
But it's doing so in circumstances where the local authority is not advancing any case on intermediate manner of provision.
Because the local authority went in believing that all provision could be met within the school day. That was obviously not a position.
But that was the very debate.
Yeah.
Between the parties.
Yes, but when the first-tier tribunal rejected that submission,
It should have another bite of the cherry.
not necessarily another bite of the cherry, and I will be very clear on that, but it should have considered. It should have taken a step back and said, on one hand, we have the interests of pupil AA, the very heavy and important interests of pupil AA. On the other hand, we have Section 9 of the Education Act that says that we mustn't use educational resources inefficiently.
Yeah.
And we should be aware that any budget that we
It shouldn't be using the resources of the first-tier tribunal nor the resources of the local authority by having an unnecessary further hearing, should they? I mean, unless the local authority is going, the local authority knows what provisions must be taken to be. I mean, it seems to me this hearing and none of this isn't a game to be played by according to rule forfeits. The first-tier tribunal's got to make a practical decision here. What outcome meets the needs as defined in the legislation.
Yes.
and it's presented with two very clear options.
Yes.
It decides on very clear reasoning that the extended school day, extended working day, extended day option is the right one here, which
Yes.
requires the involvement of residential staff. It's got two options presented to it. Is it really supposed to say, no, I don't accept that option? We have to go look for other options, which nobody suggests there are. Is that what you're really suggesting to happen?
My submission is that the First-tier Tribunal, standing in the shoes of the local authority, meeting the same duties, does have to consider those duties. And that may mean the very unpalatable consequence of saying, local authority, you are very disappointed with the way that you've presented this case. We have not found for you on the length of the school day.
They come back 6 weeks later and the local authority says, yeah, there's no other option.
Yes, that may be the consequence of it. But in the context of what of the six-figure sum that we are dealing with, arising from placement, that may be the only fair and just way to deal with the case, being fair not only to people at AA, but the ratepayers and all the other
Well, six-figure sums and being fair to ratepayers and to others, the local authority will have gone along with its options lined up. And that's the assumption that the FTT can take. It's the assumption that ratepayers can take, and it's the assumption that we, as the court, can take. Not that they will say that. Not that they will expect the FTT to do its job for it by adjourning the hearing so that the matter can be looked at again over an extended period. As Justice Lewison has said in other contexts, this is the first night and the last night of the show. We can expect that this matter is dealt with at the hearing.
Yes, and that should be the assumption, but there are other countervailing factors pulling in the other direction, and it is my submission is that
Usually, of course, you might have to adjourn if there
Yes.
is some suggestion that there is something to look at, but nobody was suggesting there was anything to look at. It's completely unrealistic to suggest the First-tier Tribunal should have its own motion have thought, well, you need to go away and see if there is another option.
with my submission, two wrongs don't make a right, as it were, in that if the local authority could have been more prepared for the First-tier Tribunal with a series of alternative options, and this is explored in Richardson.
Did the local authority say we need to go away and look at this?
Not to the best of my knowledge, and I would be remiss of me to suggest otherwise.
Even today, there's no alternative. We're on a second appeal in the Court of Appeal, and there's no alternative being positive. So, I mean, on what basis can we say it makes a difference?
The young person being part of this is coming up to potential phase transfer, of which he will be 18. At that stage, they will be,
She's 16
2
years old
years today.
and the First-tier Tribunal, the local authority wishes to, doesn't wish to, whilst there is ongoing litigation, doesn't wish to move her placement. And whilst that is, and whilst litigation is ongoing, it will respect the First-tier Tribunal's decision as upheld by the Upper-tier Tribunal. But the question of placement will have to be revisited as it would
It
under
has to
annual
be
review.
annually anyway.
Yes.
And we've already gone past
Yes.
two reviews
Yes, my lord.
since the decision was made.
Yes, my lord.
And the authority hasn't come to either of those reviews saying we've got an alternative way of doing things.
No, it hasn't. Not thus far. But it does seem that these issues, as the Commission to the Court of Appeal stated, they do need to be ventilated and clarified, particularly till round 3. If I may.
One or two further questions.
Sure,
Can I
of course,
just for clarification, did I understand you right when you said a moment ago, I think, that before the FTT there was no suggestion by the local authority that they wished to adjourn the case to go and look for another school?
they presented their case, as I understand it, on the basis that it could all be met within the school day.
And at school M.
And school day, yes.
And there was no application to adjourn to go and look elsewhere.
No.
Thank you. And I'm going to leave you to take your own course in relation to ground 3, which we'll come to in due course. But will it be relevant to look at the fact, when you look at ground 3, that by the time the FTT was considering AA situation, there was no social worker, paragraph 8 of the FTT reasons. She had been at a school that had, on common ground, failed her up to July 2023. She was receiving no education. The family was receiving limited support, and she was living in inadequate accommodation. These are all findings of the FTT.
Yes, exactly.
Yeah. So those would all be relevant, would they not, to ground 3?
They would all be relevant, yes.
So we'll put out a marker.
Yes.
We'll come back to that.
Yes.
Thank you.
And I would also say that there are other relevant considerations.
I'm sure. Thank you.
If I may return to my speaking note.
We've interrupted you very thoroughly, so we must let you make some progress.
No, that's quite all right, my lord. You've anticipated a lot of the points I want to make, and I hope that I have addressed those satisfactorily. The appellant acknowledges that the code of practice indicates that the need for residential placement should be included in section F. I think it is important that I address that. And the appellant's response is twofold. First, guidance is obviously not law, and cannot turn what is not educational into education. And it is also my submission that there must be some residential activities that have no educational characteristics.
But doesn't the fact that it's included within the code give a strong indication that the dividing line between provision and residential may be very thin, well, indeed, and maybe even in some cases non-existent?
In my submission, that they are still distinct questions that will need to be addressed, in the sense that extended day does not equate to residential provision.
Well, that may depend on the facts, mate. If you decided the extended day should be, say, 16 hours,
Yes.
you might then take the view that it could only be provided to this particular child at this particular age in a residential setting.
But if the First-tier Tribunal had done that and said, and we saw the number 16 hours per day in the working document, I suspect I would not be here. But that's not the exercise that they did undertake. They equated, in my submission, conflated extended day with residential provision. As if one automatically follows from the other. And again, I do come back to this point that it's impossible to test whether or not placement is appropriate in the abstract. It must be tested against the provision once specified. And I note that the Upper Tribunal has deprecated the use of waking day curriculum because it uses this non-statutory language. It's an unhelpful shorthand that distracts from the process that should be undertaken, which in this case was that provision is reasonably required and which placement is required, is appropriate to deliver it. And therefore, as I say, short circuits that assessment. And of course, we wouldn't demur if that concern was extended to the other phrases that sometimes get used as a substitute for waking day curriculum, extended day curriculum, is the other one, and so forth. And it is my submission, turning then back to the decision letter, that the conflation of extended day and residential placement and treating residential placement as if it was educational provision is what happened in this case. And in my submission, I've got 9 occasions in which I submit that the FTT either treated them as one single concept or treated residential as the inevitable result of this unspecified extended day. I will deal with those briefly, as I've already taken you through the letter in quite a lot of detail. But the first one, and these are all detailed in my skeleton argument, but the first one is...
Help us to go through the law.
Perhaps if I could highlight 3 or 4, that would probably be the most useful thing, but they are all detailed in my skeleton argument.
Is this well, I'm calling it paragraph 27, but my numbering seems to be slightly different from yours. Page 29.
Yes, paragraph 27, page 12 of my
Starting
skeleton
with
argument.
specifically the FTT.
Yes.
Yeah.
That's your 9 examples.
Yes. If I may just perhaps draw out at least 1 or 2 more. And the first is the first one, and it will note at paragraph 12, the FTT overtly conflates extended day with residential placement in principle. That's the heading in which it grapples with this issue. I submit that goes beyond a mere typographical error, but reveals a fundamental error in the order in which they approach these questions. There is the repeated insertion of residential staff, as is the question that's already been answered. And then there is the phrasing that the impetus of the case is whether or not she requires an extended day residential placement. This is subparagraph G, and then it's paragraph 39 of the decision letter. And similarly, at paragraph 46, and this is subparagraph I of my, which is described as the heart. And in my submission, by approaching the question of the impetus, the heart, in principle, initially, these are all words lifted from the decision letter. Of that question, they have failed to undertake the proper assessment of saying, well, this is how much this young person needs, these are the hours that they need, this is the form that it takes. Okay, can these placements deliver it? And in my submission, they have conflated those last two exercises into a single one.
I think you've made that point very, very clearly, both in writing and orally.
Dealing very briefly then with the Upper Tribunal's consideration of that is that it failed to cure or let alone acknowledge this error. And if you turn to the Upper Tribunal judgment, it's a paragraph, it's page 80, the Court of Appeal. And this is the second half of paragraph 36, where I state where it's stated that Mr. Thomas James is the residential placement presented, they are not in themselves forms of special education provision, and Upper Tribunal judge states that merely changes the focus. In my submission, this was not just a case of using it as a shorthand for the question, for it was a case of putting the cart before the horse. And then if I could now address the counter arguments put forward by my learned friend. And they appear to deal with this in 2 ways. And they say that either the tribunal was entitled to treat residential provision as educational provision, or that it was treated as an issue that straddles section F and I. And in my submission, they don't really get to that doesn't really grapple with the criticism, in that in this specific case there was conflation, and we see that the First-tier Tribunal's automatic response to the extensive provision that needs to be put in place for this young person was the residential provision. And then in my submission, that wasn't just a question of them exercising their judgment, it was restricting their judgment to an automatic result. And I have no issue with the question of this question of straddling, but that again mustn't undermine the rigour with which the tribunal must approach this, in that section I must not influence section B.
And you say there's no reason why you can't deal with 2 sections together, but you have to show that you
Yeah.
dealt with them.
We've dealt with them separately. That's the fundamental point. And then if I deal with the authority cited, and I can deal with this relatively briefly, the authority cited by my learned friend. And I don't intend to address them all encyclopedically, comprehensively, exhaustively. And this is at paragraph 10 of the skeleton argument of my learned friend. Dealing T in Hertfordshire, yes, provision and placement are closely related, but they are still separate questions. And in KW and Lewisham, my learned friend makes a perfectly common sense observation that the nature of the provision will have implications for the placement, but implications is not determination. And therefore, in my submission, it still doesn't undermine the fundamental point that we cannot conflate residential provision with placement. And again, I make no criticism of A in Hertfordshire, which appears to be treating placement and provision as separate questions. And my reading of Hammersmith and Fulham and JH, and this is at subparagraph G, page 6 of my learned friend's skeleton argument, is that it appears to be approaching the question of placement when using wake and go as a shorthand, but it's still teaching it as a separate issue. And then the remaining cases in my submission merely confirm that extended day does not necessarily require residential placement. And then in paragraph 11, my learned friend makes the criticism that my learned judges have already, my lords have already put before me, that there was there was no alternative being put forward, and as I will address in Appeal Ground 3, that misses the point that only once the provision has been specified can we then go on to consider placement, and then when we consider placement, we must consider all of the duties incumbent upon the tribunal. And again, the remainder of my learned friend's argument fails to grapple with the point that an extended day does not automatically require residential placement, and in my submission that is the error with which the First-tier Tribunal fell into in this case. Unless I can give any further assistance on Appeal Ground 1, I was going to turn to Appeal Ground 2. Appeal Ground 2 also derives from original Ground 1 that argued before the First-tier Tribunal side matters in the wrong order. It dealt with provision generally, it dealt with placement whilst it was before it specified provision. As we have ventilated this issue extensively, I don't intend to go through it with you in the same detail that I dealt with Appeal Ground 1, but if there is any points that I have missed from my skeleton that you would like me to explore.
It's really the same point, isn't it?
Not entirely, my lord, but I do take the observation that we are dealing with similar considerations. But I think that the case law assists in this, in that we have learning trust that tells us, I don't think I need to take it to you, but at tab 11, page 342, that it can only be dealt with once the provision has been identified, and we have David Lloyd-Jones telling us that they can only be addressed in this order, and he quotes, and if I could ask you to note this, is
Which page are we looking at here?
we are at, sorry, my speaking notes and my skeleton argument don't have exactly the same.
Paragraph 33, for instance.
Thank you, my lord. I'm grateful. And when he goes on to quote McCulloch J in Kingston upon Thames Council and Hunter, Part 4 cannot influence Part 3. So it goes beyond merely you've got to deal with them separately. They've almost got to be in silo boxes, if I can put it like that. Now, the Upper Tribunal judge disagreed with me, and he states that when the decision is looked at in totality, it shows that the First-tier Tribunal was aware of the logical chain and was following it, notwithstanding the headings and notwithstanding the fact that evidence under section F and concerned placement, and notwithstanding that the specification for provision did not occur until they had dealt with that matter in principle. And the Upper Tribunal judge repeatedly emphasised that the First-tier Tribunal is a specialist tribunal, and the logical chain would have been well known to them, so that he would require an indication that they had misplayed the chain in this case. And in my submission, there was sufficient indication that the First-tier Tribunal had misapplied the chain. Specifically, the Upper Tribunal erred by reframing the decision of a general assessment of evidence and effectively ignored the headings and the signposting, as well as the reasoning contained within the decision letter, which in my submission reveals that the FTT considered the placement prior to determining provisions. And if I could emphasise this point, is that headings, signposting, order, structure matter. They are the self-authored indications of by which way that the FTT is dealing with matters, and in particular in a context where the case law is so adamant that one issue should not influence the other, it is particularly important that the FTT shows that discipline and shows that rigour of dealing with issues separately. And now against me, we have at paragraph 11, paragraph 12 and paragraph 39, the correct headings are used, with that exception that residential placement and extended day are equated as one and the other. Now, the Upper Tribunal judge does find tension between the headings and the considerations that follows, and is unable to explain the use of the word thematically. And in my submission, if I may, I've got one point I want to make on the use of the word thematically, and then I want to delve into the decision letter a little further. But in my submission, that use of that word thematically, and that use of that word initially, and the use of the word then subsequently, portrays a short-circuiting error, where the issues of residential provision and therefore placement were addressed prior to specifying the provision reasons required. And I think that signposting, that self-authored structure in my submission reveals the original sin. And then if I could then just address some specific text within the decision letter. Obviously, I've already drawn your attention to paragraph 12 and the use of the word initially, thematically, and subsequently. And in my submission, this is wholly back to front in the context of particularly where, as of course noted, only one of the placements was residential and the other was not. And then at paragraph 17, they explicitly consider the evidence of an expert regarding school M, whilst we are within section F of their deliberations. And this, in my submission, goes beyond the unfortunate misplacing of a consideration of witness evidence that identifies that extended day residential provision was being under active consideration when they were specifying that provision. At paragraph 21, again we see a comparative consideration of both schools from an expert, of both school E and school M with regard to physiotherapy. Again, this is in the section that is meant to discuss what provision is reasonably required, i.e. form, content, length of physiotherapy, instead of the summation of the suitability of the two schools. And in my submission, it shows a pattern of behaviour of letting consideration of the result of the placement influence consideration of the provision. And at paragraph 30, the FTC state they have satisfied themselves that residential placement within a day was required. They now only then need to go and consider the specific provision. And as I've already mentioned in my submission, that was only back to front. That they should have specified the provision before considering whether or not, if I am wrong that residential provision can be a form of educational provision, then they should have only approached that question once they had specified the therapies that were required. And then at paragraph 34, we see the FTT state that the content of section F is directly influenced by their prior decision regarding residential placement. That again in my submission is back to front reasoning. And then this is only at paragraphs 37 and 38, once the question of residential placement has been settled, that we then get to the specification of OT and physiotherapy. At my skeleton argument, at paragraph paragraph 41, I addressed the paragraphs that the Upper Tribunal judge directed us to as being supportive of his conclusion that this was just merely a consideration of evidence and not a breakdown in the chain. And if I could, I do need to address those, if you've given me. So, paragraphs 22 and 26, the FTC note and consider the evidence of parents on need and provision, but say nothing of dealing with placement after specifying provision. And then again at paragraph 26 of the decision letter, the FTC appears oblivious to the error of approaching the question of residential placement in that abstract, which I've already criticised before. Paragraph 27, the Upper Tribunal judge relied on as well, and he says that the FTT note and consider the LA evidence on need and provision, but then in my submission equate the question of whether meeting provision after normally school hours necessitated a residential provision. It didn't deal with it separately. And I don't think there's any benefit to me reading out my skeleton argument on those points, but you have my observations that I believe the Upper Tribunal judge has been too benevolent to the First-tier Tribunal in that context. So I then deal with the specialist nature of the First-tier Tribunal. And that emphasises, and that in only my submission, emphasises the importance and the rigour and the self-discipline we should have expected from the FTT, and then makes the error more egregious because they should have been more alert to it than anyone else in that tribunal hearing. And in my submission, for the reasons above, that they have repeatedly misapplied that chain. So, in my submission, the original propositions that I put before the Upper Tribunal judge are made out, that the FTT dealt with placement while dealing with provision, and the FTT specified provision after dealing with placement. And those submissions, for those reasons I submit that this was manifested a legal error, that they dealt with issues out of order. Unless I can be any further assistance on appeal grounds 1 and 2, I was then going to turn to appeal ground 3.
Yes.
Thank you for giving that. So appeal ground 3 arises from a different original appeal ground 2, and it concerns the consideration of section 9 of the Education Act of 1996. And in my submission, the Upper Tribunal erred, not finding that the FTT had shirked its duty under Section 9 of the Education Act. And I propose to deal with this in 5 stages, which is the nature of Section 9 itself, the meaning of the word appropriate, the duties on the First-tier Tribunal, the wording of paragraph 48 of the decision letter, and then the Upper Tribunal's reasons and my learned friends' submissions regarding the inquisitorial nature of the tribunal. So dealing then with Section 9, which I've already read out, and it doesn't need repeating. So, as I'm sure the court has been aware, Section 9 has been extensively litigated, and a number of characteristics are readily apparent. The most important of which is the one I note at subparagraph E of my skeleton argument. 48E. That while Section 9 imposes a duty to have regard to parental wishes, it does not impose a duty to accede to them. And I think it might be useful to just remind ourselves what Lord Denning said about the precursor of that provision. That Section 76 does not say that pupils must in all cases be educated in accordance with the wishes of their parents. It only lays down the general principles to which the County Council must have regard. This leaves it open to the County Council to have regard to other things as well, and also to make exceptions to the general principle if it thinks fit to do so. And at this stage, I would also observe that Section 9 is not an exception, in that there are other duties on the First-tier Tribunal, or other statutory duties. And you'll recall that I began by going through the legislative framework by noting Section 19 of the Children and Families Act, again, having regard to the wishes and interests of children and family. And then we find ourselves under Section 40 and the task before us. That's the meaning of the word appropriate. And in my submission, appropriate means, in this context, in the statutory context, the consideration of all the factors, circumstances of the case, and compliance with the statutory obligations, whether or not that's Section 9 of the Education Act, Section 19 of the Children and Families Act to have regard to the wishes and feelings, Section 33 of the Children and Families Act that children must be educated in mainstream unless those very narrow exceptions apply. And so I don't think it's mutually exclusive, as some of the case law that I've cited in those footnotes may indicate, that you look at the circumstances and the statutory regime when assessing that question of appropriate. I hope I have made that point clear. Thank you, my lords. And then there's a further quotation in Hampshire County Council that I don't think actually necessarily gets much further than what I've already said, so I don't think it's worth me reading it out. But I would, obviously, for obvious reasons, like to spend a considerable amount of time on Richardson, if I may. And that is behind tab 5 and at page 284. And then we will see the quotation from Belgium, Lord Justice. And he says, "It is surely common knowledge that local education authorities have the unenviable task of eking out resources inadequate to meet all the demands upon them, and it is obvious the consequence of making over provision for one child may mean under provision for others. The tribunal were not, in my judgment, forced into the situation of ordering the authorities to specify the name of Inglefield Manor. The powers of the tribunal under section 326(3)(b) are very wide. The tribunal should at least have considered using its powers to order the authority to amend the statement by specifying the type of school. So it had that alternative open to it. It also had the alternative, as Lord Justice Gibson notes, and I'm grateful to my learned friend for correcting me in my skeleton argument to say Shyman, but my own friends obviously points that out.
Could you, in the authority itself,
Yes, my lord.
what page is Lord Justice Beldam's comment?
It is at internal page 334. Authorities bundle page 224, my lord.
Thank you.
Mark red. For your convenience.
Yep, marked up. And is the Sheeman citation marked up as well?
It is as well, my lord. But it's not Sheeman, it's that was my mistake, it's Gibson's, as Anderson pointed out. And the Gibson's quotation is at page 227 of the authorities fund. The tribunal is not obliged to order the amendments of the statement naming the school named by the parent, even if that is capable of meeting the child's educational needs and school named by the local education authority is found by the SENT not to be appropriate. It must exercise its own judgment and have regard to such matters as the duty of the LAA to avoid unreasonable expenditure and to use resources efficiently. The tribunal in such circumstances has a choice. It can adjourn the hearing to enable the authority to come up with a name of another school capable of delivering the special education provision, or it can determine the appeal by ruling against any school put forward by either party.
Sorry, are you reading from the judgment or is this your submission?
This is my submission. So, this is from the judgment, but I've extracted the relevant
So
submissions.
at the moment we've looked at, or at least you've directed us to internal page 334 of the report.
Yes, and if I may take you to 337, my lord, apologies.
Yes.
And you'll see that the section is
Subsection 3.
Subsection
3. And you emphasised it 5 lines down, it must exercise.
yes.
Okay. Is there any other part of that you particularly want us to read now?
The exploration of alternatives that Lord Gibson says, yes, yeah, the tribunal in such circumstances has a choice. It can adjourn the hearing to enable the authority to come up with the name of another school capable of delivering the special educational provision, or it can determine the appeal by ruling against any school put forward by either party which it finds inappropriate to name no school.
But this is an example which is predicated on the assumption that interpolate the FTT regards the school
As
as
overprovided.
providing far more than is needed.
Yes, I anticipated this point. In my submission, the point remains good, regardless of whether or not there's a finding of over-provision or not. The duty is not contingent on there being over-provision. There may have been an alternative way of meeting provision. And then Lord Justice Gibson develops that and says, I am further unable to agree with the suggestion to the effect that if the school named by the local authority proves not to be appropriate, no other school is positively put forward by the local authority, then the tribunal is entitled to assume there is no point in leaving the option open to the local authority to nominate another choice. The result would be, as counsel for the local authority points out, the onus would be on the local authority to put forward positively a range of alternatives in case the tribunal disagrees with the local authority's choice, with serious consequences for the length and complications of hearings before the tribunal.
Very sorry.
I'm sorry,
I was
going
making
too
notes
fast.
of the last point and I missed where you're now reading from. But where was that last extract from?
That's from the same
Same passage.
Same passage.
Top of 338.
338. Thank you.
Thank you. I'm sorry, my lord.
About 5 lines down.
Thank you.
And then we see Richardson applied in Silladin at tab 6, page 237.
Was it suggested to the First-tier Tribunal either that schooling provided far too much, or that what was actually required could be provided by another school apart from the school that was rejected?
It was put forward to the tribunal that it was over provision. If I can can find the exact reference for your Miss Anthony might may have it at her time.
That was because the local authority was saying that you only needed school hours
Yes.
provision.
Yes, that's right.
Now, as I understand it, what's being considered here is where it is there's no dispute. Sorry, or just Peter Gibson's analysis assumes there is a determined provision required. And the problem then is that effectively there are two choices, neither of which is suitable. And what just Peter Gibson says is it can't be right that you either just go with the inappropriate choice of the parents or you name no school.
Yeah.
That's I understand what he's saying, and so he says that he doesn't agree with Mr. Justice that if the LEA hasn't put forward a menu of schools, then you just choose one.
Forgive me, my lord. Is the point you're making is that the principle of Richardson only applies when the First-tier Tribunal has found that a school over provides, but necessarily must name it?
I think it. What it's saying is that the FTT isn't obliged to name school that it thinks isn't appropriate.
But he also says that the tribunal has a choice in such circumstances of using their case management powers.
Well, I think it's saying that they don't really have a choice. I think what they're saying is it can't be right that you either name an inappropriate school or you don't name one at all. And at that point, you can ask the LEA to go and have a look.
And in my submission, the First-tier Tribunal in this case didn't properly answer the question of whether or not this was an appropriate school, because they never tested it against Section 9. They said they didn't need to. So they never came to a conclusion and said, School E is a beautiful school. School E can meet all these needs, but it is exceptionally expensive. Would naming it in the absence of an alternative be compatible with the efficient use of resources? And they may have gone, we don't know. And they may have gone, local authority, we're very disappointed with the way that you presented your case, but we find ourselves in an unpalatable choice of choosing a very expensive provision or an unsuitable one that doesn't meet need. We find ourselves in this invidious position. Go away, have another go, but this is your last chance. They should have considered doing that. I'm not saying they necessarily had to, but according to Lord Justice Gibson, they had that autonomy, they had that choice, they had that discretion. And in my submission, they didn't exercise it.
Just go back to an earlier point, I think paragraph 38 of the FTT reasons is where we find your argument, or the local authority's argument, that physiotherapy for AA was over-provision.
Yeah.
But the FTT goes on to say that the local authority failed to provide any detailed expert evidence to the contrary beyond that assertion. I think that's the only reference I found.
I believe there was a further reference in the paragraph 11 as well, but that was my just point that because it was having to do with the length of the school day.
Yeah.
Then if I may take you to the case of Phillips where Richardson is applied. I don't think I need to dwell that long on it because he's defining the facts of the case before him are a square on with Richardson. He does elaborate quite helpfully in my submission the phrasing of a Hobson's choice, which is in my submission the error that the local authority, the First-tier Tribunal applied erroneously in this case. And if I could take you to tab 6, page 240, internal page 76. about 5 lines down under the highlighted section. I find it difficult to envisage how a determination of that important kind can be made when, as in the case of common consent here, no material was placed before them or but on behalf of the LAA as to the impact of this particular name on their resources. It could legitimately be contended that it was not open to the tribunal to reach that conclusion without first affording to the local authority appropriate opportunity, whether by evidence or submission, to address the resource implications of this particular conclusion. And therefore, in my submission, this is authority for the proposition that the inquisitorial tribunal must, through its case management powers, afford appropriate opportunity when it finds itself in the invidious choice of naming an appropriate school or naming an exceptionally expensive one, without considering saying, well, could the local authority have another go? Because we don't want to do either. And I want to be really clear that I am not claiming that the local authority is entitled to a second bite of the cherry. It's not my submission. But I do assert that the First-tier Tribunal is required to consider the compatibility of the school with Section 9 and then consider using its case management powers to see if the local authority should perhaps be given a second go in the circumstances.
If you're not submitting that they should have been given a second bite of the cherry, what's the point of the consideration? Because it ends up with it's not necessary for them to have a second bite of the cherry.
But there are in my submission, there are countervailing considerations that the First-tier Tribunal should have taken into account. That it leads us to raise the prospect that they may have very reluctantly.
So you are submitting that they should have had a second bite of the cherry.
In the circumstances of this case, but not as a legal principle.
Legal principle is they should have considered.
Yes, which they.
And the application of that legal principle in this case is they should have given a second bite of the cherry.
Yes. And in my submission, the tribunal fell into error when they said at paragraph paragraph 48. Paragraph 48. They do not need to consider the reasons for parental placement or carry out a cost comparison. It simply said we don't need to do that. In my submission, that was a misdirection in law, because they do need to consider whether or not naming school E was compatible with the efficient use of resources. Section 9 is not optional, if I can put it like that. Now, the Upper Tribunal held that it was the local authority's fault, as much if there was any error, and that the overriding objective of the public character of the appellant provides an explanation for the First-tier Tribunal's choice. And my submission in response to that is, notwithstanding that there is possibly a credible argument that the local authority could have been better prepared for this hearing, that doesn't discharge the First-tier Tribunal of its duties. They are not contingent on the parties meeting expectations. They apply regardless. And that in my submission, it fell into an error by bettering its discretion and adopting a Hobson's choice approach of saying, well, we're left with no alternative to either name a school that we don't think is appropriate or to name a very expensive school. And in my submission, they did have that choice. And irrespective of its specialist membership, it is still a judicial body, and it's subject to the rules and duties of the court and to apply the law. And in my submission, the response to the Upper Tribunal judge that the local authority could have done better is not an answer to the complaint. If we could just spend a little bit of time on paragraph 48, I just want to draw out one or two points, if I may.
48
Of the decision letter. and we'll find that at page 108 of the court manual. And you'll notice that I've already drawn your attention to the use of the words "we do not need." So they've excluded the possibility of considering of. But I would also emphasise that they use the word "therefore." In this case, however, we have determined that only School E can provide the provision that pupil AA needs, and having considered the evidence very carefully, do not consider that School M can meet her needs, and therefore we don't have to require a cost comparison. So the decision to exclude consideration of section 9 was the result of only finding one school was appropriate. In my submission, that was a mistake. Section 9 is not contingent on there only being one school that is appropriate.
And it's not solely a question of comparison either.
No.
Well, I think we understand section 9 duty, and we can see what's said here. So,
if I may then just deal with a couple of points then raised by Upper Tribunal Judge Jacobs. And I've got 6 points, but I suspect they may merge into fewer. I will try and keep them as distinct as possible. So the Upper Tribunal Judge indicates in point 1 that the First-tier Tribunal can be assumed to be familiar with the overriding objective, and that provides the context for this decision. And that's a fair assumption, but it's also a fair assumption, I would say, that the FTT meant what it said. And so when it says we do not need to deal with this, that they were speaking honestly. And so if we're going to use one assumption, we should also apply the other. Second point, if the Upper Tribunal Judge is correct that paragraphs 48 were not mere findings, were just mere findings of facts on the case presented to him, presented to the FTT, that doesn't evade the point that the FTC was required to grapple with cost. And even if we take it as highest that the FTT did apply the overriding objective, that doesn't necessarily dictate a particular outcome, because it states that there should be a proper consideration of the issues, and that any delay is subject to a proper consideration of the issues. And therefore my submission is that there couldn't have been a proper consideration of the issues because they didn't deal with section 9. And alternatively, and this is now my point 4, and apologies for losing track of numbers, is that if they were applying the overriding objective without mentioning it, then they should have said, right, this is the balance we find ourselves in. Local authority, what's your view? But then that never occurred. And this deals, and point 5 deals with the point that's already been ventilated about, well, does this only apply in cases where the first-tier tribunals knowingly adopting a school that over provides? And in my submission, no, section 9 applies regardless. And then point 6 is not necessarily directed at Upper Tribunal Jacobs, but it is directed at IM versus Croydon, which I imagine the tribunal has now familiarised itself with, that is applied quite regularly in the first-tier tribunal, and it would benefit from ventilation of these issues. It's at tab 12, page 352, and the relevant section is paragraphs 8 and 9. And you'll note, and this isn't a point that's picked up by my friend, but I should draw it to your attention, that paragraph 9 says, it seems to me that in a case where needs have been identified and in which the local education authority parents each wish a different school to be named, and in which the first-tier tribunal has to choose. So it's predicated on the assumption it has to choose between them. This is the approach that should be adopted. To such extent that a mechanistic approach of IM versus Croydon is applied, the first-tier tribunal needs to answer that first question: does it have to choose between them? And if I am versus Croydon, I think this is a point of agreement between us, is applied mechanistically, then that three-part test could lead a tribunal into error because it would ignore the requirements of section 9. So then I would now, if I may, and I should finish by lunchtime, my lords, address the counter-arguments put forward by my learned friend in a very comprehensive skeleton argument. The first point I make is my learned friend has approached this in a different, has approached it on the assumption that this can be addressed as if it, on the basis that the first-tier tribunal is an inquisitorial tribunal, and that gives explanation for what happened. And I wish I agree that the first-tier tribunal is an inquisitorial tribunal. Where I disagree with my learned friend is that she does not address, as I read her skeleton argument, with the requirement of Richardson that you must consider your options and you must grapple with section 9, both of which were not, both of which were omitted from the first-tier tribunal's decision. But if we take my learned friend's argument as highest, the inquisitorial tribunal explains what happened. If I could just emphasise that at paragraph 21, my learned friend, my submission mischaracterises the concession at footnote 16, that although we accept that in this case the FTT held on an unlawful basis that residential prohibition was reasonably required, we do not accept that ratio in Richardson only applies to cases where the FTT finds that a parent's preferred school provides, and there is no authority for that proposition. Section 9 in my submission applies regardless. And paragraph 22 of my learned friend's argument gets straight to the point, which is that an inquisitorial tribunal must inquire. The inquisitor must ask questions. That is its role. And it is for it to consider whether it had enough information at its disposal to deal with this hard case properly. And then if I could take you to paragraph, page 223 of the authority bundles, and this is back to Richardson. And unfortunately this isn't highlighted because I only identified this section after the conclusion of the authority bundle, but I thought it would be useful just to draw this to your attention.
Which page?
Page 223, my lord. And you'll see Miss Booth Casey and Mrs. Lane presented an argument. Argued that the tribunal was entitled to conclude that the authority had identified the school that they had considered appropriate to meet special educational needs, as it is proposed that the other school, or even the possibility of another school, the tribunal was entitled to order the authority to name the school proposed by the parent. And that was the argument that was rejected in Richardson, which appears to be the argument my learned friend is developing in her submissions. Paragraph 24 is actually a point of agreement, except in this case the question that the FTT had to ask was whether or not they could decide the case lawfully without exercising the choice to pursue additional evidence. And then I would deal with the case law that has been presented by my learned friend at paragraph 25. And I appreciate that the case of Bromley needs some discussion. If I could take you to page 247, my lord. And this is behind tab 7. 247 I would like to take you to, my lord.
Thank you.
And I'm afraid, again, this point only arose after the authority bundle was finalised. But if I could just draw your attention, if you could mark the date, 1999, and the appellant points out that the tribunal found that the current arrangements, this is about the second paragraph down, arrangements cost the local authority direct budget of 26,000 per year, whereas the placement of the C school would cost in the region of 46,000. In my submission, this is a materially different amount we are dealing with in this case. And then, if I could take you to page 272.
I'm sorry, I've completely missed that point. You've taken us to the finding that the authority's budget was 26,000 and this would cost 46,000.
Yes.
If they're right, this is available for consideration. What do you draw from that?
That this case before you today can be distinguished on the basis that we are dealing with a much larger sum.
Do we know what that sum is? In the papers?
Yes. Perhaps over lunch I can get you the exact reference rather than doing it like that. Yeah. If I could also make a distinction at page 272, my lord. Not 272 internal, but into 272 of the bundle. And you'll see the paragraph that begins before us, as before Owen, Justice Owen, and the principal critique of the London Borough of Bromley. And then you'll see, in addition, about halfway down, my lordship's with me. Mr. Timothy Stracker agrees that the amendments of the statement ordered by the tribunal lack specificity and laughs that even the tribunal were entitled to allocate S's needs and provision as they did. It did not follow that the only alternative to R school was C school. So that the local education authority should have been given an opportunity, particularly in the view that the true cost of the latter school was not 46,000 but 63,000 to put forward alternatives. My submission is slightly different in that I'm not saying that we automatically should, but that the First-tier Tribunal should have considered giving the local authority a further opportunity. So when we come to page 278 and the section that my learned friend has perfectly understandable reasons identified, it says that the local authority must put its full case forward, at least the extent of putting down the necessary markers. That must be understood in the context in which Mr. Stracker was asking for an automatic automatic rule that he was entitled to a second go. That's not our submission, but we are entitled to consideration of a second go. And then I can deal with the remainder of the authorities cited by my learned friend relatively briefly. The case of Rhonda is consistent with my submissions, and it merely confirms that it is a judgment call, not an automatic right to a second go. And this, the case of Hillingdon, the third case cited by my learned friend, does not undermine the proposition that the First-tier Tribunal should consider extending. It may consider that local authorities in such default that the overriding objective does not require extension. As an inquisitor, it must inquire and ask the question. W versus Gloucester emphasises the use of the phrase when the occasion arises, and in my submission, the occasion did arise in this case. And then Islington versus Islington and a parent, if I may spend a little bit of time on that. And this is at page 388 of the bundle. you'll see on page 288, you'll see a summary of the decision, and it emphasises that there's no burden on the local authority to prove its case. It's an inquisitorial tribunal. And then if I could take you to paragraph 62 at page 425. And this is Upper Tribunal Jacobs, and this is Upper Tribunal Stout. Says, I am therefore satisfied that in this case the first-tier tribunal erred in law in directing itself. The burden of proof was on the local authority to demonstrate that naming the parent's preferred school would be incompatible with the efficient use of resources, rather than recognising that it was its responsibility as a tribunal to stand in the shoes of the local authority and apply section 39(4), and B, failing to exercise, and you'll note, you won't be surprised that I will emphasise the different parentheses, or failing to consider exercising its case management powers to obtain the necessary evidence on costs on both placements. At the point it decided the evidence had been cited as unreliable. My learned friend will say that this is a different set of facts, but my submission would be that those principles are good, and that if you fail to take responsibility for the decision that you are forced to make, and ensuring that you make it on a lawful basis, that's still an error of law, and that you should consider exercising those case management powers. And then last point, you have a look at page 427. At page 65, Upper Tribunal Judge Stout says, on the other hand, had the tribunal properly considered the exercise of its discretion, it would have taken into account very significant prejudice to the local authority of not adjourning, given that it would result in the school of parental placement being named with an attendant significant additional cost to the local authority. I noticed the use of the phrase very significant prejudice. And then at page 429, Upper Tribunal Stout describes £48,000 to £60,000 last year as a significant sum of public money to benchmark the submissions that follow. My learned friend, obviously, for perfectly understandable reasons, relies on the question of case of Pivchekbek. Apologies if I mispronounced that. And my response to that case is that a failure of one party does not absolve the judge of making an error in another. And it is also incumbent on the First-tier Tribunal to ensure that they have asked the right question. So I now anticipate, in response to my to the judge's question, to the observations about why it was pressing that there was a decision to be made there and then, and it is a perfectly legitimate point to raise, but I would point to at least 4 considerations on the other side. My submission, the sum was very significant. Second, and this I suspect is my most critical point, the FTT is not the budget holder. They do not have to live with the consequences of their actions, and that imbues upon them a particular need for rigour and restraint and discipline. Or as I put it in my skeleton, as I put it in my note here, a disjunct between the decision maker and the budget holder invites caution. The third point is this is the SEN budget we are allocating. That has clear implications for other children in SEN. And the fourth point is the parlous state of the local authorities' SEN funding, which we can take from the authorities was an issue 20 years ago and remains one. So in those circumstances, notwithstanding the very compelling point that my Lord makes, in my submission that we're confronted with either side of the balance, the FTT to have considered adjourning, and if it had considered, it would have, I suspect, reluctantly and grudgingly adjourned one further attempt for local authority. And it is my submission that, particularly in this context where the budget holder and the decision maker are separate, the local authority is entitled to a rigorous approach. And notwithstanding that the local authority may have been in default itself, it didn't receive that rigorous approach. And of course that cuts both ways, and that any parents before the first-tier tribunal are equally entitled to a very rigorous approach as well. Unless I can be of any further assistance, that concludes my submissions on appeal
So
grounds.
you're going to address us on whether it's academic.
Yes. The pupil AA's placement will be considered again in accordance with Part 3 of the Children's Families Act, and that may result in an appeal. And it is my submission, it is important and necessary for this case, but also other cases that appear in the first-tier tribunal, that this is done on a properly lawful basis. And I hope my lordship don't fear that I'm giving evidence that this issue of where a parent pursues an independent placement, which is not section 41 registered, and the local authority is proposing an alternative, does occur with relative frequency in the first-tier tribunal. And it is something that has, and is a cause of.
Maybe we should say very clearly that if local authorities think that the school placement that the parents are seeking is going to be on their budget,
Yeah.
they should go prepared to say so.
Absolutely. And that they should, but equally, the first-tier tribunal should, when it is imposing an onerous burden on the local authority's budget, must apply the law.
But how would this work? You get to the end of the first-tier tribunal hearing and reach the conclusion that you've reached so far.
Yeah.
What do you then say? Well, local authority, do you want an adjournment? Do you have to do that in every case?
They have to consider it.
Well, you've made that point.
Yeah.
Definitely.
Definitely. Slandered, my lord. They would turn its mind to the question of saying we are confronted with an invidious situation of where we are imposing onerous burden on the budget of the local authority, but we also must resolve this case quickly for the obvious needs of the young person, and they must balance that. Now that may, in exercise of their discretion and the overriding objective and their powers, involve going, what do you say about that local authority? Or it may involve them relying on their expert knowledge and their experience as a first-tier tribunal and going, right, we don't think we need to adjourn in this case, or regrettably we have to adjourn in this case. It may not necessarily involve representation to the point.
What's very unclear to me is what you're asking us to do. If you look at your notice of appeal, you challenge the order of the tribunal. You wish to appeal against the order of the tribunal dated the 29th of November. And then when it says, what are you asking the appeal court to do? The answer is set aside the order I'm appealing. So all you're asking us to do is to set aside the upper tribunal.
Yes.
That leaves the first-tier tribunal order extant. Are you saying the case should go back to the upper tribunal? What are you saying?
I'm grateful, my lord, and I appreciate the need for clarity on this. My skeleton concluded with we're asking the first-tier tribunal decision to be quashed. What we are certainly seeking is a declaration that the first-tier
Why would we quash a decision made 2 years ago that this child AA goes to school E? There's no suggestion that that isn't the right solution. I mean, it would be a very misleading thing. And I don't actually think you're submitting to us that the end of the day is the substantively wrong outcome. Simply, it's a reasons challenge, isn't it? Or a procedure and reasons challenge.
I wouldn't, in my submission, I don't think it's entirely fair to characterise it as that. I would characterise it as saying that there was a difficult decision between the First-tier Tribunal. It is very important to my client that it was both in rigour and discipline, and that they failed to. And that needs to be acknowledged and marked.
Well, no, we don't do that. Though. We don't acknowledge and mark those things. We give judgments on decisions about whether they were right or wrong or not.
And on my submission that you should mark that the Upper Tribunal judge got it wrong, and
leave aside what we might say in a judgment. What are you asking us to order? What order are you asking us to make?
my instructions are that we are seeking quashing of the decision of the First-tier Tribunal. In addition, we would be also seeking a declaration that they applied the law incorrectly. For obvious reasons, we are not pursuing costs in that case.
Or you were prevented. Well, you haven't given us any formal declaration. Where do you find this declaration? We don't.
When you say we want a declaration, what you really want us to do is to clarify the law.
Yes, my lord. And clarify that it was
So
misapplied
that
in
should
this
come
case.
in our reasons. It's not a separate relief that you want.
No.
So you want us to quash the decision below, which leaves you that to remit the question to some other tribunal
To a freshly constituted tribunal, yes.
to deal with it
As it would be dealt with as of today.
as of today.
Yeah.
But you don't need that.
No.
So that is academic because you can make a fresh decision.
Yes, and it would be made with the benefit of your judgment.
So you don't actually want us to quash and remit.
My instructions are
Well, that's I'm saying your structure, but looking at what makes sense.
Yeah.
It would only make sense for us to quash the decision, wouldn't it, if we were going to remit it for further to be remade.
Yeah.
Otherwise, there's no provision of this child in place.
The local authority would maintain the placement whilst the case was reheard.
But you don't need that because you can review the ECH anyway.
Yes, we can. I absolutely take the point. I take the point, my lord, that the practical consequences may be what they are. I remain in the position that I operate within my instructions, which is to seek quashing order. I absolutely take the point that there may be alternatives. The policy of the local authority is not to change this position whilst it's under
Is it fair to say that quashing the decision would be academic? Because it's been in operation for 2 years. You've got the ability to review it.
Yeah.
If we quashed it, all it would mean is there was a vacuum for the last 2 years.
Yeah.
Because it would be nonsense to go back and remake that decision.
Right.
So really, any order we repeal is academic, and the question really is it appropriate? Is it an appropriate case where we nevertheless proceed with the appeal because of the important consequences?
Yes, and there are important points of principle that apply to my client and other local authorities. And as I mentioned earlier, this issue does arise with considerable frequency in the First-tier Tribunal.
Can I just be absolutely clear? My lord has asked about the annual review. But is it your client's position that whatever they do, whatever we do,
yes,
you will continue to maintain AA under the present setup until she reaches 18?
I could take explicit instruction on that one. No, not until she's 18.
Not until she's 18.
Yeah, and that's
Will not
yeah.
will not interfere with the present arrangements until she comes out of the up to 18 regime,
Academic, yes, that's right.
in which case this really is academic. Okay, well, sorry, that's a revision of you.
Well, but I would emphasise that this case, that this issue does need to be particularly in relation to Iron versus Croydon, which is applied frequently in the First-tier Tribunal. That this issue does need to be clarified.
In which case it should come to this court on a case where it matters. It's going to affect that. You've taken us through a lot of authority. You say there's no real dispute about the need for a logical chain.
Yeah.
You've got all these marvellous arguments about, I don't mean rudely,
No.
you've got all your very carefully constructed arguments about whether or not logical chain is being followed and whether it matters, and you've got your ground 3 arguments.
Yeah.
Okay.
I think we'll just, before we adjourn, we'll just retire very briefly and come back in and see where we're going to go from there. So you can wait in court.
All rise and wait. All rise and wait.
You will now adjourn until 2 o'clock. Ms. Anderson, we would like to hear from you on ground 3. We do not want to hear from you on grounds 1 and 2.
Thank you.